Court then calls case of the people versus Henry Williams.
On behalf of and on behalf of Mr. Williams, who should be present via Zoom. Sir, can you please unmute, turn on your camera, and state your name for the court?
Before a single name is called, understand what kind of courtroom this is. This is not a trial courtroom built on dramatic testimony and surprise witnesses. This is a plea courtroom, where consequences move fast, paperwork matters more than passion, and one wrong answer can quietly change the course of someone's life. Today, Judge Simpson is moving through a packed docket in Michigan, and what looks routine on paper quickly turns revealing. You'll see defendants pleading guilty over Zoom, others unsure whether they're even on probation, and one person who vanishes so completely a bench warrant is issued on the spot. These cases range from letting the wrong person drive a car, to retail theft, to drug paraphernalia, bond violations, and missed court appearances. But the real story is accountability. Watch how Judge Simpson carefully walks defendants through their rights, warns them of consequences they clearly hadn't thought through, and balances efficiency with fairness. Some defendants are honest, others hesitate. A few joke at exactly the wrong time. And here's the key tension. Most of these people are already under court supervision. One misstep here doesn't just mean a fine, it can trigger jail time somewhere else. As this docket unfolds, pay attention to how quickly freedom can hinge on a single "Yes, Your Honor."
Hello?
Hello, what's your name?
Henry Williams.
Okay, you have to get someplace where you're stationary.
Yes, sir.
But I have before me a plea form that indicates that he's going to plead to an added count 2 of allowing an eligible person to operate a motor vehicle. That's the 90-day offense. Upon successful plea to that charge, count 1 would be dismissed.
That's correct. Yes, Your Honor.
Sir, if you can please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Henry Williams.
All right, sir, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of allowing an ineligible person to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days, and a $100 fine plus court costs. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
This is one of those moments that sounds simple but carries weight far beyond the words. When Henry Williams pleads guilty, he's not just accepting responsibility. He's waiving nearly every protection the justice system gives him. No trial, no appeal, no second-guessing later. Judge Simpson is methodical here for a reason. Courts must ensure that guilty pleas are knowing, voluntary, and intelligent, or they can be overturned later. That's why you hear this checklist-style questioning. But here's where the tension creeps in. Henry can't clearly answer whether he's on probation. That's a red flag. In real terms, pleading guilty while on probation can trigger a probation violation, and that other judge doesn't have to be lenient. Judge Simpson does the right thing by slowing down and warning him directly. This isn't theatrics. It's legal triage. Audience question. If you were unsure about your probation status, would you still plead guilty today? Or would you stop everything and confirm first? One honest mistake here could lead to maximum penalties somewhere else.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that you're giving up those rights as well as all the rights on that form?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
I believe so.
Were you on probation in 2023? Not going to matter, quite frankly. Sir, were you on probation in 2023?
I'm not positive, but probably.
Okay, but are you off probation now?
No, I'm not off probation. No, sir.
All right, let me just do it this way. Sir, if you are on probation, I'd have to advise your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, that other court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
And understanding all that, you still wish to plead guilty to this charge?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
October 2nd, 2023, at the location of Packard Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes, sir.
Counsel, have I complied with the court rule, or would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed.
Notice how quickly this case wraps up once the plea is accepted. That speed is deceptive. The consequences, however, linger. Henry thanks the judge and mentions money immediately. And that tells you everything about where his stress really is. Fines and costs may sound minor compared to jail, but unpaid court debt is one of the most common ways people end up back in court. Judge Simpson gives him time, but also gives him a deadline, and even injects humor about Thanksgiving. That humor serves a purpose. It softens the moment while making the expectation crystal clear. Pay, or you're back here. The court isn't punishing poverty, but it is demanding responsibility. This is how low-level cases quietly stack up. One missed payment, one ignored deadline. Suddenly, it's a warrant. And that's how routine pleas turn into life disruptions.
Sir, anything you want to say before I impose sentence?
Just thank you, and I'll have your money soon, Judge Simpson.
All right. Fines and costs of $250. When can you get that paid?
I'm starting a new job here soon, but I owe a lot of other court fees, so I'm gonna get on the payment plan. I'm on the bridge card, so I'm working on it as soon as possible. So as
I
long
don't
as
know what that means. Can you get it done before October 31st?
I can get something paid. I can get definitely something paid.
Pay it by December 1st,
Yes, sir.
2025. If somebody says Happy Thanksgiving and you haven't paid me, we're in trouble. You're in.
Yes, sir.
Bless you, Mr. Barry. Court does call the case of the people versus Nicholas Stocker.
Conrad Siller on behalf of the township.
Good afternoon, this is the public defender Lauren Tierney on behalf of Mr. Stalker. Your Honor.
He's in Zoom. Sir, can you unmute, state your name?
Yep, Nicholas Stocker, Your Honor.
Thank you.
Your Honor, we do have a resolution. Mr. Stalker is going to be pleading as charged with an agreement to pay restitution. I will.
Restitution of $189 payable to Lowe's through the court.
Yes, I will also note that there's a note in the docket that he has a warrant in out of 1483. We did submit a warrant recall on the 29th, and it says that it's been sent to the Judge Freshour to review. I don't have an update on that, but we did send a warrant recall.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again.
Nicholas Anthony Stocker.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud under the Pittsfield Township Ordinance. It is a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor, I do.
And to that charge, how do you plead?
I plead guilty, Your Honor.
Nicholas Stalker's case introduces another layer, restitution. Retail fraud cases aren't just about punishment. They're about making the victim whole. In this case, Lowe's. The court ensures the amount is clearly stated, payable through the court, not directly to the store. That detail matters because it creates a formal record. What's striking here is Nicholas's honesty. He admits outright that he went to steal. No excuses, no deflection. Judges notice that. While it doesn't erase the charge, it does build credibility, especially when sentencing is still ahead. But there's tension too. There's a pending warrant issue floating in the background. Even when a plea is clean, unresolved warrants can derail everything. Audience question: do you think courts should reward honesty at sentencing? Or should the punishment be the same regardless of attitude?
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do, Your Honor.
Had you reviewed it and signed an advice of rights form? With
I did.
permission? Do you have any questions regarding those rights?
No, I do not.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I'm on probation, Your Honor.
Were you on probation at the time of this offense in 2023?
No, I was not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes, I am.
of your own free will,
Yes.
and because you believe that you are indeed guilty?
Yes.
May 25th, 2023, at the location of 3900 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Lowe's that makes you think that you're guilty?
I went to the Lowe's with the sole purpose of stealing, and I went in there and removed merchandise without paying for it.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No, I did not.
And the property that you took was property that was offered for sale by Lowe's?
Yes.
Counsel, well, sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, any sentence agreement or evaluation, the court will no longer be bound by, and you understand that you cannot withdraw your plea.
Yes.
Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 24th, 2025, 9 a.m.
This referral to probation is critical. A pre-sentence investigation report isn't just paperwork. It's the blueprint for sentencing. It examines criminal history, compliance, substance use, employment, and risk. What defendants say today can echo loudly later. Judge Simpson also warns Nicholas about misconduct between plea and sentencing. This is a trap many defendants fall into. They think the hard part is over. It's not. One violation now, and any sentencing agreement can vanish. This gap between plea and sentencing is where discipline matters most, and where many cases unravel.
Bond will continue. Thank you, sir.
Thank you.
Oh, sir, hold on a second. He's gone. Court does call the case People versus Randolph Taylor.
Conrad Hill on behalf of Pittsfield Township.
Assistant Public Defender Natalie Payne for Mr. Taylor, who I do not believe is present, Your Honor. Also make a
Randolph Taylor, bench warrant.
Oh, sorry. I just wanted to briefly, for the record, I request an adjournment. I do not have an email address for him. The number I had for him was bad.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000, 10%. That warrant will issue immediately. Who do they have? Court does call the case People versus Michael Collison.
Good afternoon, Your Honor. Ashley Feltus for the people.
Ron Brown appearing on behalf of Mr. Collison, Your Honor.
All right.
Mr. Collison will be pleading no contest to the bond violation. As the basis, I can tender the report from the Community Corrections.
I have that. So he's pleading no contest.
Yes, Your Honor, potential civil liability as there was damage to the tether. So the potential charges could be filed against him.
Okay. I will accept his plea of no contest to the bond violations.
This case shifts tone. Michael Collison isn't arguing guilt. He's arguing for treatment over jail. His attorney lays out time-served, therapy, recovery programs, and the lack of a finalized plan. Judge Simpson listens, but notice the balance. Empathy without blind trust. Courts increasingly recognize addiction as a driver of criminal behavior, but treatment only works when it's structured. Without a written plan, the judge can't just gamble. So he sets another date. This is the justice system walking a tightrope between rehabilitation and accountability.
May I address?
You may.
Your Honor, I have been in contact with Don Farm. Robert Carl, his primary therapist, sent over in correspondence If the court would like to review it, I don't want to make ex parte contact, or I could read it into the record for the prosecutor. Also, I've been in contact with Oakdale Recovery. So Ms. Dussault was on vacation until this morning. She indicated verbally before going on vacation that he would be welcome back into the Oakdale Recovery Program. So I'm providing the court with alternative solutions other than a jail sentence to allow him to complete treatment. He has approximately 140 days in. He spent from March 8th, and he was released on May 21st. And then again, he was rearrested on the bond violation on the 24th of July and has remained in custody continuously for 41 days. So he has
But
approximately,
right now, there is not a plan, and I don't have a written plan for him in terms of treatment.
I'll get it.
Okay.
I've reached out to 2 different placements, Your Honor, but I have not received a plan.
I'll set a sentencing on his bond violation for September. Well, I could do the 24th. I'll just set it for the 17th, the Wednesday, because that gives me an earlier date.
Thank you.
And I'll set that at what time you want me to set that? 3 p.m.
Thank you.
All right.
And if I get it sooner,
Get it sooner, then I'll take a look at it sooner.
thank you.
All right, thank you. Court does call the case People versus Christopher Mary.
Conrad Siller on behalf of Plainfield Township.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Mary.
25-10631. Your name?
Christopher Mary.
All right, what are we doing?
Your Honor, we have, he's here to plea and we have a deferred sentence approval.
The plea form that indicates he's pleading guilty. Well, what is he pleading? Because I don't have.
He's pleading guilty to the possession of drug paraphernalia.
And the 90-day offense upon which is as charged, I do, right? And for a deferred sentence, I do see that. I haven't sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Christopher Mary.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of possession of drug paraphernalia. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs under the Pittsfield Township Ordinance. You understand that?
I do.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights. They are part of the trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
I am.
Of your own free will?
Yes.
And because you believe that you're indeed guilty of this offense?
Yes.
On the date of May 18, 2025, Carpenter Road in Pittsfield Township, Washington County, State of Michigan, did you have a crack pipe in your possession?
Yeah, I was in possession of drug paraphernalia.
Well, did you have a crack pipe? What did you have that you believed to be drug paraphernalia?
Yes, a crack pipe.
All right. And you knew that you had it?
Yes.
All right. And it was yours?
Yes.
All right. Sir, if I accept your plea, between the time of your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rule, any sentence agreement, such as the deferred in this case, or any other evaluation, the court would no longer be bound by. You understand that?
Yes.
Counsel, are you aware of any other threats, promises, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor, aside from the deferred sentence agreement.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred.
Christopher Mary's case highlights how even minor charges demand clarity. When the judge presses him on what he possessed, the hesitation matters. Courts need a factual basis for every plea. Drug paraphernalia isn't enough. The record must be specific. Once clarified, the deferred sentence becomes the key. This is a chance, not a gift. One violation and the protection disappears. Judge Simpson makes that unmistakably clear. Audience question: do deferred sentences genuinely help people change? Or do they just delay consequences?
To probation for a pre-sentence investigation and report. Sentencing in this matter will be September 24th, 2025. 9 a.m. Or
Your Honor, I apologize. Is there a chance of another date?
what's my next one? October 8th.
Correct.
October 8th, 2025, 9 a.m. Or as your invite indicates. All right. On will continue. Thank you. Yes, sir. Take care of yourself. I know, it's Maryland. Always have looked good and red. You know, I don't know who they're playing this week. I was just glad they got past Florida Atlantic. God help us all.
All right. Thank you, Your Honor.
Court calls the case, People versus Jacqueline Murray.
Ashley Feltus for the people.
Howard Patel on behalf of Ms. Murray. Ms. Murray, please approach the podium and state your name for the record.
I'm Jacqueline Murray.
Your Honor, today is a date and time set for motion hearing. I was recently appointed on this case, but realized after reviewing the discovery that I had represented one of the complaining witnesses in this case, so I'm required to withdraw. At this point, I ask the court grant my motion.
Ma'am, you have any questions or objections to that?
No.
I will grant the motion. I'll sign the order. The MAC office has appointed Ed Drukas to represent you. Ma'am,
Thank you,
okay?
Your Honor.
Pardon? Oh, is it? Okay.
Yep. I'm here, Your Honor. I'd just be asking for an adjournment to collect the discovery and have an opportunity to go and see her.
Adjourn this then to September 17th, 2025, 9 a.m. All right, ma'am.
Thank you, Your Honor.
Thank you.
This moment is procedural, but important. A conflict of interest requires withdrawal. It protects the defendant and the integrity of the system. The court doesn't rush it. New counsel is appointed. Time is granted. Justice isn't just about speed, it's about fairness. Even routine adjournments serve that purpose.
Thank you. Court does call the case of the People versus Wesley Voss.
Henry Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Patewick on behalf of Mr. Voss, who is present via Zoom, Your Honor. However, he was texting me that his camera, can't figure out how to turn it on, but he should be connected via audio. Sir, can you please unmute and state your name for the court?
Calls case of the People versus Sydney Wack.
Henry Silver on behalf of Pittsfield Township.
Assistant Public Defender Lauren Kearney on behalf of Ms. Black. Ms. Black,
Yeah, I'm here today.
Okay.
you know, we believe Ms. Black is valid. If you could,
You mean as a person or a license?
both.
No, I'm kidding.
Good answer.
She is valid.
Excellent.
Both as a person and her license. So, all right.
Given that, she would like to accept the prosecutor's offer.
I move to add count 2 of double parking. If you accept that admission, you dismiss the charge.
Yes, I accept that.
Okay. And, ma'am, do you admit responsibility to the fact that on May 29, 2025, Washington Avenue in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, I do.
All right. Court will accept that admission to count 2. Count 1's dismissed. Fines and cost of $180. When can you get that paid?
Can I just have 30 days?
Okay. Not in jail. I'm sorry, Ms. Wag. I'm sorry. I shouldn't be messing with you. You can pay by October 3rd?
Yes, I can.
Okay. I'll just indicate pay that by October 3rd, 2025. All right. Thank you.
Thank you.
You have a great evening.
Thank you, you too.
Court calls case People versus Javante White.
Henry Silver on behalf of Pittsfield Township.
Assistant Public Defender on behalf of Mr. White, who gave me permission to accept the offer on his behalf.
I move to add count 2 of double parking. If you accept that admission, we'll dismiss the original charge. He does have a valid license.
Ms. Pate, do you admit responsibility on behalf of your client to the fact that on July 12, 2025, location in Pittsfield Township, that being Michigan Avenue, that he did double park a motor vehicle? The court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can that be paid?
He was asking 1 month, Your Honor.
Pay it by October 3rd, 2025.
Today's docket may look ordinary, but it reveals the justice system in its most honest form. Guilty pleas accepted carefully. Warnings given clearly. Opportunities offered, and consequences enforced without hesitation. Judge Simpson balances efficiency with precision, reminding every defendant that the court listens, but it also remembers. Across these cases, one theme is constant. Responsibility doesn't end with a plea. It begins there. Miss a payment, miss a hearing, or violate conditions, and the system responds fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.